everyone, and welcome back to Learning to Change the Law. I'm your host, Jess Watson, and this week we'll be considering the controversial topic of counterterrorism and law in Australia. Due to COVID-19, our guest speakers have unfortunately not been able to come together for our usual in-person panel discussion, but today we're trying something a little bit different, and we've put together a very informative video for your education and enjoyment. Starting off today, we have Jess Williamson, who will be providing some context and relevant background information about terrorism and counterterrorism laws in Australia, followed by Maddy McWaters, who will be discussing why this theme is so important, followed by myself, finally concluding what theories have been taught in the Law Advocacy and Activism Unit, which are relevant to our discussion around human rights and counterterrorism in Australia. So sit back, relax, and enjoy the video.
Thanks, Jess. Since the September 11 attack of 2001 in the United States, the war on terror and the state of emergency that has ensued has become a fairly normal state of affairs for us. In response to this deadly attack, the United Nations Security Council passed Resolution 1373. This binding resolution placed an obligation on all members of the international community to denounce terrorism in all its forms and to introduce domestic measures to prevent terrorism occurring on home soil, as well as to stop acts that might facilitate terrorism overseas, such as the funding of terrorist groups. In response to Resolution 1373, the Australian government rapidly introduced new anti-terror laws, as was necessary given Australia didn't have any such specific laws prior to 9/11. Since then, often in response to deadly terrorist attacks across the globe, such as the London and Bali bombings, the Australian Parliament has partaken in what is commonly and appropriately termed the hyper-legislation of anti-terror law. Under the Howard government alone, from 2001 to 2007, the Federal Parliament enacted 48 new anti-terror laws. Many academics and civil society groups have criticised just how far Australia has gone in upholding its obligation to prevent terrorism. The extremely rapid pace at which these laws are pushed through Parliament has seen the process of democratic parliamentary scrutiny compromised and has produced laws that are arguably neither proportionate to their aims or effective in achieving them, nor respecting of our political and civil rights under international human rights law. However, the language of war, urgency, and exceptional circumstances has allowed the government to quickly introduce laws that would not have been readily accepted by the public under any other circumstances, given their impact on our rights, or allowed to remain in force without revision for such a long time. And, in retrospect, this rush wasn't even necessary. For example, while the legislation that introduced preventative detention orders passed through Parliament in just over a month, they weren't first used until nearly 9 years after this. And in the absence of an instrument such as a Bill of Rights, it has been difficult to challenge even the most questionable of anti-terrorism measures, such as control orders, preventative detention orders, or the use of secret evidence. Our judges have had a very limited role in examining terrorism laws. As in the Thomas v. Marbury case, the courts are restricted to determining the issue of the constitutionality of laws, not their compliance with international human rights. Further, subsequent governments have been unwilling to look at the legislation in place, brushing aside reports such as the Council of Australian Government and the Independent National Security Legislation Monitor, both of which concluded that many of Australia's anti-terror laws are too broad and lack appropriate safeguards, and therefore need to be repealed or adjusted. So, even while the threat of domestic terrorism has seemed to be in decline in recent years, the normalisation of anti-terrorism measures in our legal system has allowed these laws to endure and even be extended, such as how the anti-terrorism specific control orders have now migrated into the criminal justice context in the so-called war on bikies. Maddy will now talk about why this is so significant.
Thank you, Jess, for touching briefly on counter-terrorism in the context of the Australian legal system. The reason it's so important to look at this theme is, as we mentioned, the fact that these laws are so rapidly passed through Parliament, have a significant impact on our rights and freedoms, and despite being branded as exceptional in nature, have more recently been migrated into the criminal justice context. A main reason why hyper-legislation occurs without appropriate safeguards is due to Australia not having a Bill of Rights. Freedom of speech and opinion, privacy and a right to a fair trial are all human rights and are lost to preventative detention and use of a secret evidence in trials. Furthermore, a right to silence is taken away from the prosecuted as the ASIO can issue detention warrants for refusing to not answer questions and is a criminal offence punishable by 5 years. Scrutiny of terrorism is a lot deeper than normal criminal cases, specifically under control orders. These control orders are not compliant in the international human rights standard. They also prevent freedom of movement and undermine the presumption of innocence, and provide fewer rights than when charged. However, if these are breached, the consequences are much higher than an ordinary case. You can really start to understand now how complex terrorism is in Australia. To combat hyper-legislation in Australia's lack of a federal Bill of Human Rights, the Human Rights Parliamentary Scrutiny Act of 2011 has been created. The main focus of this model is to examine bills and legislation, including delegated legislation, for compatibility with international human rights standards. On paper, it seems to be a perfect alternative to Australia not having human rights legislation. However, the model cannot prevent a bill from becoming a law. The quality of scrutiny is often rushed in this context and has become a process of box ticking rather than a safeguarding measure. Particularly with the issue of statelessness, a consequence of strict terrorism laws, including the Australian Citizenship Amendment Act of 2015, that conflicts with Article 5 of the Universal Declaration of Human Rights. Having a person as stateless is both unethical and dangerous for future motivated attacks. More appropriate safeguards should be looked into to avoid the permanent state of emergency Australia has created for society. Sunset clauses are useful for checking rush laws, and extending sunset clauses past 10 years would force the Australian government to re-examine laws and act as a form of a safeguard before they expire. For example, the original control regime was supposed to expire in November 2015, but was extended by counter-terrorism legislation, the Foreign Fighters Bill 2014 to 2018, and extended again to 2021 by a subsequent piece of legislation. The major issue for Parliament is that it would be enacting strong laws largely in response to overseas events. Any possible threat to Australia is unknown and the responses are unfamiliar. While overseas measures may offer some suggested approaches, they must be placed in context. For example, the United Kingdom has a range of counter-terrorist laws, but those laws have a very specific context of the Northern Ireland enduring conflict. Comparative approaches by counter-terrorism are a relevant part of the debate in Australia, but so too is a measured appreciation of the specific threat to Australia posed by terrorism. A terrorism investigation into a crime is unique as it is a crime that has yet to occur. The purpose of legislation is preemptive and to stop terrorist attacks because they are dangerous in the fact that the motivation is extreme and radicalised. The current criminal justice model does not fit with the anti-terror preventative intelligence model. The criminal justice model is a post-crime evidence gathered about past events, whereas the preventative model is a pre-crime focus on future events. Terrorism is not motivated by money, unlike drug dealing, and the standard of evidence occurs at an earlier stage than it does for traditional crime, and the length of the investigation is complex and long. Another significant issue that warrants examination is the normalisation and migration of counter-terrorism laws in the criminal justice system. Within a year of Thomas v Mowbray giving the constitutional okay to control orders, the South Australian Parliament enacted the Serious Organisational Crime Control Act of 2008. This statute was created as an anti-bikie law and marketed as part of the state's efforts to combat outlaw motorcycle gangs. Each control order statute was supported by a tough on crime, war on bikies expression that emphasised the imminent threat posed by these groups. Increased reliance on secret evidence has been identified as an inevitable consequence of the intelligence-led approach adopted by Australia to meeting the threat of transnational terrorism following 9/11. A domestic anti-terror policy with both vertical and horizontal migration of anti-terror laws has occurred in Australia with the normalisation of the anti-terror policies. As a result, there are now a serious organised crime control orders in all but the ACT and Tasmania, and Victoria is the only jurisdiction to enact control orders provisions and be subject to a human rights charter. This contains additional protections in the form of a special counsel to assist the respondent in respect of the criminal intelligence applications. Other states should look to have a similar model. Interagency cooperation, in particular between state, federal, police and ASIO, is vital to continue to combat terrorism in an effective way. Prior to 9/11, there was no interaction or link between police and intelligence agencies. The process of consultation to collaboration is working well with room to improve. Police language is different to ASIO and does not contain the same meaning. So if the police say they're going to perform a search warrant, in an ASIO context that can allude to a very different interpretation. But unless you take the time to actually build that level of understanding, these relationships won't be more integrated.
Advocacy and activism in the area of counter-terrorism law comes with significant challenges, given the very controversial nature of the topic. As human rights advocacy groups work to monitor the government to prevent it from overreaching in its powers and curtailing the rights of its citizens in its effort to stop terrorist attacks, these groups face criticism that they do not have their priorities right in defending the rights of terrorists or suspected terrorists instead of the rights of the victims of terrorism. This is called the legitimacy gap by the International Council on Human Rights, and in the face of the fear that terrorism incites within the community, this poses a real problem to the effectiveness of advocacy and activism and producing the political will necessary for reform. For example, the Law Council of Australia ranks the review and reform of Australia's anti-terror laws as a top priority, and consistently produces submissions to Parliament, media releases and presents speeches on the topic, highlighting the inconsistencies with Australia's international human rights obligations and the lack of safeguards, but admits its advocacy has been met with only limited success.
The Australian Human Rights Commission has similarly advocated for compliance with international human rights standards through frequent submissions to parliamentary inquiries and reviews on anti-terror law, with only a limited impact observed. Liberty Victoria is an example of an advocacy group that aims to combat terrorism hyper-legislation. The main argument that comes from this group is that Victoria has an obligation to human rights law, and through these counter-terrorism laws, the state continues to have a violation of international law. More advocacy groups like Liberty Victoria could continue to advocate for change of these laws. However, as previously discussed, these groups have had little effect on reform due to the legitimacy gap that remains both legally and socially entrenched in society. Perhaps advocacy in this area is largely dominated by formalised, legally orientated bodies, such as those mentioned due to the complex legal nature of the issues resulting from Australia's anti-terror laws and due to the general acceptance of a need for terrorism measures within the community.
The Law Advocacy, Activism and Change Unit at the University of Western Australia touches on the key theories of human rights, utilitarian theory, natural law theory and natural rights theory, which can be used to further explain and understand Australia's current counter-terrorism laws and attitude towards national security and human rights. To begin, what are human rights? Well, according to the Australian Human Rights Commission, human rights recognise the inherent value of each person, regardless of background, where we live, what we look like, what we think, or even what we believe. They are based on principles of dignity, equality, and mutual respect, which are shared across cultures, religions, and philosophies. They're about being treated fairly, treating others fairly, and having the ability to make genuine choices in our daily lives. The Universal Declaration of Human Rights, first adopted by the United Nations in 1948, sets out the basic rights and freedoms which should apply to all people. The Australian Government has agreed to uphold and respect many of these human rights treaties, for example, including the International Covenant on Civil and Political Rights. It is the Australian Human Rights Commission's responsibility to monitor Australia's performance in meeting its international human rights commitments. Utilitarian theory, first conceptualised by Jeremy Bentham, determines right from wrong by focusing on outcomes. Utilitarianism holds that the most ethical choice is the one that will produce the greatest good for the greatest number. And often it is this utilitarian approach which has been used to justify the state for the mistreatment and almost unjust persecution of terrorist activity, as it is in the best interest of national security and protecting the majority population from harm. Throughout history, different countries, societies and cultures have defined or clarified human rights to suit their own contexts. In some communities, human rights include a specific set of laws and legislation. In others, human rights are simply guidelines that reflect the morals and expectations of individuals within the community. The concept of natural rights arises from the belief that there is an instinctive human ability to distinguish from right and wrong. Natural rights theories inspired revolutionary ideas and democratic struggles, forcing politics to protect the rights of citizens. Natural rights theories imply that all human beings are equal and should be treated equally. The demand for equality before the law in individual states is synonymous with the development of international human rights law. Making human rights an integral part of the law and policy-making process helps create the framework for a human rights approach to counter-terrorism laws. This may be done by possibly introducing a statutory charter of human rights. It is beyond question that it is one of the responsibilities of a liberal democratic government to protect the citizenry from physical harm and the threat thereof. However, the duty to protect is but one of the several interrelated and indivisible obligations of government. These include, most importantly, the fundamental obligation to respect human rights. A policy that does not respect human rights in the first place cannot legitimately claim to protect these rights against transnational security threats in times of emergency. The overarching principle was that governments should give domestic force to international human rights law by introducing explicit statutory protections for human rights. Respect for human rights and the rule of law must be the bedrock of the global fight against terrorism. This requires the development of national counter-terrorism strategies that seek to prevent acts of terrorism, prosecute those responsible for such criminal acts, and promote and protect human rights and the rule of law. It implies measures to address the conditions conducive to the spread of terrorism, including the lack of rule of law and violations of human rights, ethnic, national and religious discrimination, political exclusion and socio-economic marginalisation, to foster the active participation and leadership of civil society, to condemn human rights violations, prohibit them in national law, promptly investigating and prosecuting them and preventing them, and to give due attention to the rights of victims of human rights violations, for instance through restitution and compensation. So the questions I now ask are, in the present political environment, how do we reconcile the government's retreat from fundamental rights under new anti-terrorism laws with international human rights and fundamental freedoms? Is the threat of a terrorist attack in Australia justification enough to elevate the right of human security above all, above the protection of even our most fundamental human rights? As mentioned, terrorism is a highly emotive topic. Because of this, the reform of anti-terrorism law will need significant political will to be achieved. Considering these factors, we would recommend that advocacy and activism groups focus on the framing of their arguments for reform to be achieved more successfully in this area, especially taking into consideration the public's perceptions of terrorism. For example, the submission made by Prosecute Don't Perpetrate to the Joint Parliamentary Committee on Intelligence and Security for the review of citizenship deprivation legislation highlighted how such a measure is detrimental to the victims of war crimes perpetuated by terrorists, as the cessation of citizenship also relieves the Australian government of its obligation to investigate these crimes perpetuated by Australian citizens on foreign soil. This approach taken by Prosecute Don't Perpetrate bridges the legitimacy gap by putting the rights of victims first and demonstrates impartiality in wanting to assist the victims of terrorism, as well as hold the government to account, but would equally achieve the end result of the reform and/or repeal of laws that breach human rights without compromising credibility. Well, that's it for today. Thank you everyone for tuning in to this week's episode of Counter-Terrorism and the Law. We hope to see you next week for the topic of aged care and the law. Stay safe and we will see you all next week.